Good afternoon. Again, I am Judge Sonia Brown, the presiding judge for the trial of the state of Georgia versus Matthew Scott Lands, 22-900-922. We are present here in the open courtroom. Present of the court, the clerk, the court reporter, Mr. Lands. He is represented by Attorney Jimmy Berry, and the state is represented by Assistant District Attorneys Green and Horowitz. In the Superior Court of Cobb County, state of Georgia, the state of Georgia versus Matthew Scott Lands, defendant, criminal action file number 22-900-922. Non-jury judgment after bench trial. Defendant having waived his right to trial by jury, the parties having consented to a bench trial before the court, and the bench trial having commenced at November 17th, 2025 at 9 a.m.
Before we get to the verdicts, notice something important. This was a bench trial, meaning the defendant waived his right to a jury and placed the decision entirely in the judge's hands. That's a high-stakes strategic choice. Now the courtroom is about to hear the result of weeks of evidence distilled into a single ruling. Do you think you would ever choose a judge over a jury if your future depended on it?
Now, therefore, after considering the evidence admitted during the bench trial, the parties' arguments, and the applicable law, the court finds as follows. As to count 1, malice murder, the court finds the defendant, Matthew Scott Lands, guilty. As to count 2, malice murder, the court finds the defendant, Matthew Scott Lands, guilty. As to count 3, felony murder, the court finds the defendant, Matthew Scott Lands.
Listen to the pattern here, count after count. The word is guilty. In criminal court, every count must be evaluated separately, and the judge is methodically working through each charge. The steady pace almost makes it sound routine, but each finding carries enormous legal consequences. You can feel the weight of the moment building with every verdict announced.
Guilty. As to count 4, felony murder, the court finds the defendant, Matthew Scott Lands, guilty. As to count 5, felony murder, the court finds the defendant, Matthew Scott Lands, guilty. As to count 6, felony murder, the court finds the defendant, Matthew Scott Lands, guilty. As to count 7, home invasion, the court finds the defendant, Matthew Scott Lands, guilty. As to count 8, aggravated assault, the court finds the defendant, Matthew Scott Lands.
And there it is. All 13 counts result in guilty verdicts. For the prosecution, this represents a complete courtroom victory. For the defense, the focus now shifts from arguing innocence to limiting the consequences at sentencing. The trial may be over, but one of the most emotional phases of the case is still ahead.
Guilty. As to count 9, aggravated assault, the court finds the defendant, Matthew Scott Lands, guilty. As to count 10, possession of firearm during commission of a felony, the court finds the defendant, Matthew Scott Lands, guilty. As to count 11, possession of firearm during commission of a felony, the court finds the defendant, Matthew Scott Lands, guilty. As to count 12, cruelty to children in the second degree, the court finds the defendant, Matthew Scott Lands, guilty. As to count 13, tampering with evidence, the court finds the defendant, Matthew Scott Lands, guilty. This 20th day of November 2025.
This is where many viewers are surprised. A guilty verdict doesn't automatically end the proceedings. The next stage is sentencing, where victim impact statements, mitigation arguments, and recommendations from both sides can influence the final punishment. Sometimes the most powerful testimony in a case comes after the verdict has already been reached.
Signed and affixed with my signature, Judge Sonia N. Brown. Would you all like to take a look at the form?
No, Your Honor.
Okay. All right, Madam Clerk, if you would please enter this non-jury judgment after bench trial into the record of the court. Thank you. All right, I will hear from the state and the defense regarding sentencing.
Your Honor, we had talked, I know that the state has quite a large number of people that want to speak. I think it probably would be wise to start that in the morning.
What you're hearing now is a housekeeping matter for the record. but it's more significant than it sounds. Attorneys often clarify exactly what evidence was or wasn't provided during deliberations to create a clean appellate record. In major cases, details like these can become important if the conviction is later challenged in a higher court.
So we can get through with it tomorrow.
Okay. Stay.
We don't have any objection to that. Thank you.
Okay. All right, so we will stand in recess until 10 a.m. tomorrow morning, in which time both the state and the defense will have an opportunity to present arguments.
The courtroom is heading into recess, but the story isn't over. Tomorrow's sentencing hearing will determine how these guilty verdicts translate into real-world consequences. After hearing the judge find the defendant guilty on every count, what sentence do you think the court is likely to impose? The next chapter could be just as dramatic as the verdict itself.
And any statements from any victim impact statements or statements in mitigation on behalf of Mr. Lambs.
Thank you, Judge.
Right? We'll stand in recess until 10 a.m. tomorrow morning. Oh, one moment. Oh, one moment, please. Court is still in session.
Your Honor, just for the record, and I apologize for not putting this on the record prior, but as for your deliberations, the following exhibits were not provided to Your Honor.
Thank you.
That was State's Exhibit 670, an ATF crime lab report, State's 671, another ATF lab report, State's 917, which was the Google search history, State's 607, which was the ZebTech OZ9 of the defendant's gun. State's Exhibit 468 was not an exhibit. It was never tendered. It wasn't missed. It just was never, that number was never used.
Okay.
And then finally, of course, we did not provide Your Honor with Master Drive A, which contains State's Exhibits 5, 7, 460, 462, 463, 464, 465, 466, 467, 469, 470, 471, 472, 473, 474, 481, 685, and 686.
Okay.
Thank you.
Attorney Barry?
We agree with that, Judge.
Okay. Right, and all the evidence has been brought and placed back in court.
Thank you so much.
All right, we'll stand in recess until 10 a.m. tomorrow morning.
Thank you, Your Honor.
Thank you. Deputies, we do have a status hearing. Well, Floyd, I guess not the fast one. I have a status hearing at 1:30 on a separate case.
Okay.
Okay, so we'll be in session at 1:30, but it's on a separate case.
Yes, ma'am.
Thank you.
Thank you.